Welcome to the Lion's Share podcast, where we break down today's most impactful research and bring fresh insights from the academic frontier straight to you.
This is where we cut through the noise, skip the summaries, and really get into the critical insights from some heavyweight research.
That's right.
Our mission today, it's pretty specialized, but honestly vital for anyone working where finance, law, and corporate strategy meet.
Mm-hmm.
We're tackling a really complex question.
Mm-hmm.
Is there a causal link between the risk of being sued, litigation risk, and what companies choose to disclose voluntarily?
Yeah, it's a tricky one.
Specifically, we're going deep, really deep, into a key paper from the Accounting Review in 2019. It's Litigation Risk and Voluntary Disclosure: Evidence from Legal Changes by Houston, Lin, Liu, and Wei.
Absolutely. And for those of you tuned in wanting that rigorous academic take, maybe you're doing a DBA or a PhD, we're not just hitting the highlights.
Yeah.
We were really dissecting the how, the mechanism.
Yeah.
This whole deep dive, it's structured around digging into the paper's identification strategy, how they isolated the effect.
It's just quite clever.
It is. And the econometric methods they used, which are pretty sophisticated, and maybe most importantly, what this all means for managers, how it shifts our thinking about corporate transparency.
Right.
So the goal is really to leave you with a solid, structured grasp of how that external legal world really shapes fundamental disclosure choices inside the firm.
Okay, let's start unpacking this. We need to set the scene, technically speaking, because this isn't just saying, oh, these things happen together.
No. Yeah.
It's about trying to nail down causality, which, as you said, decades of research before this really struggled with. So the big question the RQ the author started with was basically, does the fear of getting sued make companies share more information voluntarily, or does it make them clam up and share less?
Right. And the problem was, if you just looked at the older studies, you got mixed signals. Totally inconclusive, really.
Why was that? It seems straightforward.
Well, it boils down to this really thorny issue called endogeneity.
Mm-hmm.
Disclosure is a choice managers make, right? But the risk of getting sued is tangled up with that choice. They influence each other. High risk might change disclosure, but the way you disclose might also change your risk.
Ah, okay. Chicken and egg.
Exactly. That was the classic problem. If you saw maybe companies in high-risk industries disclosing less often.
Like biotech or tech back in the day.
Precisely. You couldn't be sure why. Was the high risk itself forcing them to be quiet? Or was there some other hidden factor? Maybe they just had really volatile businesses or, different management styles.
That caused both the high risk and the low disclosure.
Exactly. So you had correlation, lots of it, but proving causation. That was the missing piece.
So how did Houston and his colleagues get around this? What was their methodological innovation?
Their solution was, I think, quite elegant, really. They stepped away from looking at things driven by management choice. Instead, they found these moments in time, legal changes that were plausibly exogenous.
Meaning external, outside the company's control.
Yes, exactly. External shocks. Unanticipated legal shifts that suddenly changed the rules of the game. But only for some firms, not others.
Okay, and what were these shocks they used? You mentioned 3.
That's right. They used what we call a multifaceted identification strategy relying on more than one event, which adds a lot of credibility. The main one, the workhorse event, was a Ninth Circuit court ruling back in 1999.
The Silicon Graphics case.
That's the one. It came seemingly out of the blue and imposed a much, much tougher standard for plaintiffs trying to bring securities class action lawsuits. Suddenly, it was harder to sue companies located in those 9 Western states under the Ninth Circuit's jurisdiction.
So for those specific firms, litigation risk effectively dropped overnight.
Pretty much, yeah. A sudden, geographically defined decrease in risk.
And the other 2 events.
They also looked at a Supreme Court decision in 2007. This one actually went the other way. It reversed some of those tough Ninth Circuit pleading standards.
Ah, so it increased risk again for those same firms.
Yes, providing a sort of natural reverse experiment. And the third one was different again, a change in Nevada's state corporate law in 2001. This offered directors and officers more liability protection, but it wasn't related to class actions, more general liability.
Okay, so 3 distinct legal shifts affecting different groups or types of risk. How did they use these events methodologically?
By leveraging these clear, time-bound, and often geographically limited changes, they could deploy what's really considered the gold standard for this kind of causal research, a matching-based, fixed effect, differences design. Or DORDO for short.
Right. And what does that let you do? in simple terms?
It lets you compare the treated firms, those affected by the legal change, like the ones in the Ninth Circuit after '99, with a carefully chosen group of control firms.
Firms that were similar but not affected by that specific ruling.
Exactly, matched firms outside the Ninth Circuit. You compare how the disclosure practices of the treated group change after the event, relative to the change observed in the control group over the same period.
And that difference is the estimated causal effect of the legal change.
Precisely. It isolates the impact of the ruling from all the other stuff happening at the same time, like, the tech bubble rising and falling, or other economy-wide shifts.
Okay, so they run the sophisticated analysis. What's the headline finding? Does risk encourage or discourage disclosure?
They found a clear, positive relationship. Litigation risk encourages voluntary disclosure.
So when the risk of being sued went down after that 1999 Ninth Circuit ruling,
Firms suddenly started making fewer management earnings forecasts. They disclosed less.
fewer forecasts overall, but was it just a general reduction?
No, and this is really the critical piece of the puzzle. The drop in disclosure wasn't random across the board. It was specifically concentrated in forecasts that conveyed negative news, bad news forecasts.
So when the legal threat eased, managers primarily stopped issuing the bad news forecasts they might have otherwise put out.
Exactly. This strongly validates, using this rigorous causal setup, the idea that a major reason companies disclose voluntarily is to deter lawsuits. Specifically, lawsuits that might arise from hiding bad news. Disclosure acts like a shield.
Got it. Disclosure as a defensive strategy. Hashtag 8.2. Managerial relevance and practitioner takeaways. Okay, let's shift gears slightly. We've established the academic contribution, nailing down causality. But what does this mean for someone in the C-suite, a CFO, a general counsel, someone crafting disclosure policy? What's the big practical takeaway?
I think the biggest takeaway is really a fundamental reframing of why companies disclose voluntarily. Managers need to see it not just as, a way to keep the market happy or lower capital cost.
Which is the standard finance textbook view.
Right. They need to internalize that it is, first and foremost, a pretty sophisticated legal risk management tool. It's a conscious defensive mechanism.
So the paper shows that if you're operating in a high-risk legal environment, you tend to forecast more.
Yes. And conversely, if that legal risk suddenly drops, as it did for the Ninth Circuit firms, you forecast less. This tells you that disclosure has real costs, time, effort, potential competitive disadvantage, and managers will dial it back if the legal pressure eases off. Liability reduction often seems to trump maximal transparency.
That really does run counter to the pure finance idea that more disclosure is always better because it lowers information asymmetry and your cost of capital.
It does. And the reason it makes sense is because of the nature of securities litigation risk. The liability threat isn't symmetrical.
What do you mean by asymmetric?
Managers have to grasp this. The vast majority of big, costly securities class action lawsuits, the ones based on the fraud on the market theory, get triggered by a large, unexpected drop in the stock price.
Okay.
And that price drop is often presented as evidence that the company must have been hiding negative, material information from the market. The lawsuit claims an omission of bad news.
So the real legal danger isn't so much saying something slightly optimistic that doesn't quite pan out.
Exactly. It's the danger of not saying something bad that then comes out later and tanks the stock.
Yeah.
Rule 10b-5 covers both misstatements and omissions, but the big hammer tends to fall on omissions.
So the fear of being sued for saying too little about bad news is greater than the fear of being sued for being a bit wrong about potentially good news.
That's what the evidence strongly suggests. And this paper shows managers respond directly to that asymmetry. When risk drops, they cut back specifically on the bad news forecasts.
Interesting. Does the paper say anything about how they use disclosure as a defense? Is it just about getting the news out?
It suggests that controlling the intensity of disclosure, basically, the frequency, how often you put out forecasts, is a key tactic.
Why frequency?
Well, think about how class action lawsuits work. They define a class period, the time during which the alleged fraud, like omitting bad news, occurred. If you forecast frequently, you effectively shorten any potential window where you could be accused of hiding something.
So more frequent forecasts mean any potential class period is shorter, potentially limiting the size of the damages.
Exactly. It's a deliberate way to manage the potential financial fallout from litigation. Controlling the volume and timing seems to be a primary defensive strategy. Hashtag 823. Key terms and concepts.
Okay, we've thrown around some pretty technical terms. Before we dive into the structured questions, let's just quickly define maybe three core concepts that are absolutely vital to really appreciating the rigor here.
Good idea. Let's start with the trigger itself. Exogenous variation or shock, we use that term. Why was the 1999 Ninth Circuit ruling such a good example of this?
Right. In plain English, why was it exogenous? Why was it external and unanticipated?
Okay, so this ruling happened in the context of a specific case, the Silicon Graphics case. And it wasn't like Congress passed a new law. It was the court interpreting an existing law, the Private Securities Litigation Reform Act, or PSLRA. They drastically changed the standard plaintiffs needed to meet just to get their lawsuit started.
Moving towards needing to show deliberately reckless intent.
Right. A much higher bar. This is a court-driven reinterpretation, shown and external to what individual companies were doing. Crucially, it only applied to firms physically located in those 9 states.
So that geographical boundary is key.
Absolutely key. It created this clean divide between firms whose risk suddenly changed, the treated group, and those whose risk didn't, the control group. And that division wasn't based on the firm's own choices or characteristics. They couldn't just pick up and move easily to avoid it. That makes it a clean instrument to study the effect of the risk change itself.
Okay, concept 2, the methodology. Matching-based fixed effect difference in differences. That's a mouthful.
Yeah.
Let's break down why this combo is so powerful for validity.
It is powerful. Think of it as a 2-step process to fight off major methodological headaches, like selection bias and omitted variables.
Start with the matching part, PSM.
Right, propensity score matching.
Yeah.
SM. The problem is firms weren't randomly assigned to be in the Ninth Circuit, right? They chose to be there. So they might be different in fundamental ways from firms elsewhere.
Like more tech firms in California.
Exactly. So PSM is a statistical technique to build a better comparison group. You take each Ninth Circuit firm, treated, and find one or more non-Ninth Circuit firms, control, that looked really similar before the ruling happened.
Similar in what way?
On observable characteristics that might influence disclosure, things like their size, their debt levels, their industry, how volatile their stock was, analyst following, R&D spending, that sort of thing.
So you create a control group that, on paper, looked just like the treated group before the legal shock.
That's the goal. It makes the later comparison much more credible. Then comes the second stage, the DIE with fixed effects.
What would the fixed effects add?
They add another layer of control, especially for things you can't easily observe or match on. Firm fixed effects basically control for anything about a company that's stable over time, its unique culture, its management quality, whatever. It nests out those constant differences.
Okay.
And then the really powerful one here is industry by year fixed effects. This controls for anything happening to a specific industry in a specific year.
Like the tech bubble bursting, affecting all software companies in 2000.
Precisely. If the entire software industry, nationwide, saw a drop in disclosure during that time, the industry by year fixed effect accounts for that industry-wide trend. It ensures you're isolating only the additional change experienced by the software firms inside the Ninth Circuit, which you can then attribute to the legal ruling.
Wow, okay. That's layers upon layers of control. Very rigorous.
It is. It's about as close as you can get to a true experiment in this kind of setting.
And the third key concept, the asymmetric loss function. We touched on this, but let's just crystallize it.
Right. This is the core behavioral theory underpinning the findings. It's the idea that the potential cost, the loss from getting sued, isn't the same for all types of disclosure problems.
You mean omitting bad news versus misstating good news?
Exactly. Under U.S. securities law, particularly Rule 10b-5, there are protections, sort of safe harbors, for forward-looking statements made in good faith, even if they turn out wrong. But the law is much harsher on omitting material negative facts, hiding the bad news. Because the potential damages from a lawsuit triggered by a massive stock drop after bad news finally comes out are often far, far higher than damages from a forecast being slightly off.
So managers are rationally more scared of the omission lawsuit.
That's the theory. Their strategic priority becomes avoiding that big omission lawsuit. And the way to do that is to preemptively disclose negative news. This asymmetry drives the finding that when the legal threat drops, it's the negative news disclosures that get cut first.
All right, let's formally structure this around the key questions now. Question 1, what is the specific research question and why was it so important to tackle it? We know the basic question, but let's focus on the importance, particularly that endogeneity challenge.
Okay, the specific RQ is really about identifying the causal effect. How does a change in litigation risk cause a change in corporate voluntary disclosure, specifically management earnings forecasts?
And the importance lies in overcoming those endogeneity problems that plagued earlier work. You mentioned 3 types.
Yes, the endogeneity problem here was like a three-headed beast. You had reverse causality, measurement issues, and omitted variables, all potentially confusing the picture.
Let's revisit reverse causality. How does disclosure affect risk, making it hard to study the effect of risk on disclosure?
It's fundamental. We think risk drives disclosure choices. But the choices managers make about disclosure, like forecasting frequently, can actually influence their future litigation risk.
How so?
Like we mentioned with the class period, if you disclose more often, you might shorten the window for potential lawsuits, reducing your ex-post risk exposure. So the thing you're trying to explain disclosure is feeding back and changing the thing you think is causing it.
Risk feedback loop.
Exactly. A simple regression can't untangle that. You need something, like this external legal shock, that hits risk but isn't caused by the firm's recent disclosure choices.
Okay, the second endogeneity beast. Measurement imperfection. How did older studies typically try to measure litigation risk, and what was the flaw?
Often, they'd use proxies based on the firm's own characteristics or history. Things like how volatile its stock returns were, what industry it was in, like biotech or tech, which just gets sued more,
Right.
or even how many times the firm had been sued in the past. The trouble is, these measures capture a whole lot more than just the external legal environment.
Like what?
Well, high stock volatility might go along with riskier management or a more uncertain business model, which could also influence disclosure, completely separate from the legal risk. Industry membership captures common business practices, not just legal threats. These proxies were just noisy and mixed up legal risk with other internal factors.
So using the geographical location relative to the court ruling gives a cleaner measure of the change in the external legal threat itself.
Much cleaner. It's not about the firm's internal characteristics. It's about the legal rules they suddenly operate under, just based on where their headquarters are.
And the third challenge, a classic in accounting research, omitted variables, especially around 1999.
Oh, definitely. That period was wild. You had the dot-com boom peaking and about to crash. You had Regulation Fair Disclosure, Reg FD, coming in 2000, which itself dramatically changed disclosure rules for everyone. You had changes in auditing standards.
So if you just saw disclosure patterns changing in California around then,
You couldn't just assume it was because of the Ninth Circuit ruling. It could easily have been the tech bust hitting Silicon Valley particularly hard, or firms adjusting to Reg FD. These are major omitted variables that could create a spurious correlation.
and the Desidy strategy, especially with those industry-by-year fixed effects, is the main weapon against that.
It's the crucial defense. It controls for those simultaneous time-varying factors, economy-wide trends, industry-specific shocks, allowing you to isolate, hopefully, just the effect of the legal change itself. Overcoming these 3 endogeneity issues was really the main contribution here.
Okay, moving to question 2. The theories. We know Rule 10b-5 creates this tension, don't lie, but also don't hide material facts. How did the authors frame the competing theories about how managers might react to litigation risk based on this?
Right, the law itself points in 2 potentially conflicting directions for managers thinking about disclosure.
Let's start with the theory predicting more disclosure when risk is high. The litigation deterrence idea.
That's the one often associated with Skinner's work back in '94. Theory 1, you could call it. It argues that managers anticipate the possibility of getting sued for omission for hiding bad news. To head that off, to deter those lawsuits, they choose to disclose preemptively. They get the bad news out there themselves. This shortens the potential class period, maybe reduces potential damages, makes a lawsuit less likely or less damaging if it happens.
So under this theory, higher litigation risk leads to more voluntary disclosure, especially of potential bad news. A positive relationship.
Exactly. Disclosure is a shield.
But there's an opposing view, right? Theory 2.
Yes. Theory 2 focuses on the other side of Rule 10b-5. The prohibition against making untrue statements or misstatements.
The fear of getting sued for saying something that turns out wrong.
Precisely. Especially with voluntary forecasts, which are often forward-looking. The future is uncertain, forecasts can easily be wrong in hindsight. If managers are primarily worried about this kind of lawsuit being sued because a forecast didn't pan out, then an increase in general litigation risk might make them less likely to say anything voluntarily.
They'd just clam up to avoid the risk of misstatement liability.
Right. Under this theory, higher litigation risk would lead to less voluntary disclosure. a negative relationship. Silence is safer.
So the literature before this paper had theoretical arguments pointing in both directions, and the empirical evidence was mixed. How did this paper resolve which theory seems to dominate in practice?
It resolves it by strongly supporting the asymmetric loss function idea we discussed earlier.
Remind us.
The idea that the practical economic risk from omitting bad news, leading to a stock crash and a huge lawsuit, is generally far greater than the risk from making a forward-looking statement that turns out to be modestly inaccurate, which often has safe harbor protections.
So theory one, the fear of omission lawsuits, is the bigger driver.
That's what the evidence points to. The legal and economic reality makes managers more concerned about the consequences of hiding bad news. Therefore, their primary defensive disclosure strategy is focused on mitigating that specific risk.
And this theoretical leaning is why the authors specifically tested whether the effect differed for good news versus bad news forecasts.
Absolutely. If the asymmetric loss function theory is right, you'd expect the reaction to a change in litigation risk to be concentrated on the bad news disclosures. Finding exactly that result provides powerful empirical validation for theory one being the dominant force.
All right, question 3 is about the research design's quality. How well does it hold up against threats to validity? This is crucial for the academic audience. Let's focus first on internal validity, the confidence that the Ninth Circuit ruling caused the change in disclosure, not something else.
Internal validity is job one in causal research. The authors built several layers of defense here. First, they had to show the legal change was real and actually did reduce litigation risk. Was it truly exogenous and effective?
How did they demonstrate the ruling had teeth? Did lawsuit filings actually drop?
Yes, they looked directly at that. Table 3 in the paper is key here. It shows that actual securities class action filings in the Ninth Circuit dropped significantly more, about 50% more, than filings in other circuits right after the 1999 ruling.
Okay, so the treatment actually worked. The legal environment changed measurably.
Exactly. It wasn't just a theoretical change. It had a real impact on plaintiffs' ability or willingness to file suits.
What about the parallel pre-trend assumption? This is always a big hurdle for DID designs. Did the Ninth Circuit firms and the control firms really look like they were on similar disclosure paths before 1999?
This is critical. If the treated group was already changing its disclosure differently before the ruling, the DID estimate is biased. They address this in two main ways.
First,
the propensity score matching itself was designed to create groups that were similar on observables, including their past disclosure frequency before the ruling. That helps ensure you start with comparable groups.
and second,
They provided visual evidence. Figure 1 in the paper plots the average forecast frequency for both groups over time. You can see the lines tracking each other pretty closely in the years leading up to 1999. They also ran statistical tests in Table 2, confirming that being in the Ninth Circuit wasn't significantly predicted by pre-existing disclosure patterns.
So it looks like the groups were trending similarly beforehand, supporting the idea that the divergence after 1999 was due to the ruling.
It strongly supports that, yes. It suggests the ruling was the shock that broke the parallel trend.
And we already discussed the fixed effects firm FE, and especially industry by year FE, as controls for omitted variables like the tech bubble. That also bolsters internal validity.
Hugely. Those fixed effects soak up so many potential confounding factors, really helping to isolate the ruling's specific impact.
Okay, let's shift to construct validity. Were they actually measuring what they claim to be measuring, litigation risk and voluntary disclosure?
I think the construct validity is quite strong here. For voluntary disclosure, they focused on management earnings forecasts, MES.
Why MEFs?
Well, they're a very direct, observable, and quantifiable form of voluntary disclosure. Companies choose whether and when to issue them, and you can track their frequency and even classify their news content, good news versus bad news, relatively easily. It's a first-order disclosure decision.
And litigation risk.
As we discussed, the key measure here was the geographical location of the firm's headquarters relative to the Ninth Circuit's jurisdiction. This directly ties the treatment, the change in risk, to the specific legal ruling, rather than relying on those noisy, endogenous firm characteristics used in prior studies.
Makes sense. Finally, external validity. How generalizable are these findings? Can we be confident this isn't just something weird about California tech firms in 1999?
This is a real strength of the paper, I think. They didn't just rely on the one 1999 event. They used that multifaceted identification strategy with 3 separate legal shocks.
The 99 Ninth Circuit ruling, risk down, the 2007 Supreme Court reversal, risk up, and the 2001 Nevada law change. different type of risk down.
Exactly. Finding consistent results across these three different events, different time periods, different directions of risk change, even slightly different types of legal liability involved, makes a much stronger case for generalizability.
It suggests this positive relationship between litigation risk and voluntary disclosure isn't just an artifact of one specific setting.
Precisely. It suggests it's a more fundamental aspect of how corporations respond to the legal environment that significantly boosts the external validity.
Question 4 digs into the econometric nuts and bolts. The core method is that difference in differences regression, using OLS on the interaction term. But the real rigor comes from how they set it up and defended it. We know PSM helped with non-random assignment, but can you remind us what they matched on?
Sure, the propensity score matching, PSM, was vital because, again, firms choose where they locate. To build that credible control group, they matched each treated Ninth Circuit firm to one or more untreated firms based on a range of characteristics measured before the 1999 ruling.
Like what kinds of characteristics?
Things known to correlate with both litigation risk and disclosure choices. So, firm size, measured by assets. Leverage, or how much debt they had. Stock return volatility, riskier firms might disclose differently. Analyst coverage firms, followed by more analysts, face different pressures. R&D intensity, often linked to information asymmetry. And crucially, they also matched on the firm's past voluntary disclosure intensity itself.
Why match on past disclosure?
To make sure you're comparing firms that had similar disclosure habits before the shock. You don't want to compare a firm that always disclosed a lot to one that never did and attribute the difference solely to the legal change.
So matching on these specific covariates helps ensure the control group is truly comparable, strengthening the core DD assumption.
Exactly. It minimizes that selection bias, making the counterfactual what would have happened to the treated firms without the ruling much more plausible.
Now, back to the fixed effects for handling omitted variable bias. You emphasize the industry X-year fixed effects. Let's maybe elaborate a bit more on why that's so much better than just, say, putting in dummy variables for each year.
Okay, think about it practically. In the 1999-2001 period, a lot was happening, right? Tech bubble, Reg FD.
Right.
If you only include year fixed effects, you're assuming these events affected all industries equally in each year, which is clearly not true. The tech bus hit tech firms way harder than, say, utility companies. What industry-by-year fixed effects does is allow for a unique baseline effect for every single industry in every single year. It's like estimating a separate intercept for the software industry in 2000, another for the software industry in 2001, another for pharmaceuticals in 2000, and so on.
Thousands of separate effects being controlled for simultaneously.
Exactly. So if all software firms nationwide cut back disclosure by, say, 10% in 2001 because of the general tech downturn, that 10% industry year effect is completely absorbed by the fixed effect.
Leaving only the additional change observed specifically for software firms located in the Ninth Circuit to be attributed to the legal ruling.
That's the idea. It's an incredibly stringent way to filter out the influence of simultaneous confounding events that vary across both time and industry.
And they did other checks too, right? Like removing tech firms.
Yes, to really nail the point that it wasn't just the tech bubble, they showed the main results held, even when they completely excluded high-tech firms from the sample. They also did things like restricting the sample to firms that consistently forecasted before the event and used quarterly data in a shorter window to minimize contamination from other events.
So multiple robustness checks backing the main finding.
Definitely. It's that combination, PSM for selection, DD for the basic design, and these very strong fixed effects plus robustness checks for omitted variables that really builds the case for a credible causal estimate.
Let's get to the payoff then. Question 5. What were the main results, quantitatively? And did they definitively answer that core research question about the causal link?
Yes, I'd say they answered it quite definitively. The main findings are laid out clearly, especially in Table 4, which looks at the impact of that 1999 ruling.
What did Table 4 show?
It showed that the reduction in litigation risk caused firms headquartered in the Ninth Circuit to become, on average, 6 percentage points less likely to issue any management earnings forecast in a given year compared to their matched counterparts outside the circuit.
6% less likely. That seems meaningful. Was there also an effect on the number of forecasts?
Yes. The ruling also led to a reduction in the annual frequency of forecasts by about 0.57 forecasts per firm per year, again relative to the control group.
Wow, over half a forecast less per year. Given that many firms only issue a few forecasts annually, that's a pretty substantial cutback.
It is. It's a clear indication of a real change in managerial disclosure strategy directly linked to the change in legal risk, and it confirms the positive relationship. Less risk leads to less disclosure.
So this directly supports the litigation deterring motive for disclosure. When the deterrence pressure eased, the disclosure level dropped.
Exactly. It suggests managers weren't just disclosing out of the goodness of their hearts or solely for capital market benefits. They were doing it, at least partly, because the legal environment compelled them to.
Now, the really interesting part, the asymmetric effect. Did the results back up the theory that the fear of omitting bad news is the primary driver?
They did, very strongly. That's shown in Table 6, where they break down the effect based on the news content, whether the forecast conveyed good news or bad news relative to expectations.
And what did that breakdown show?
It showed that the overall decline in the likelihood and frequency of forecasts was driven almost entirely by a significant reduction in negative news forecasts.
Really? So they basically stopped issuing the bad news warnings?
Largely, yes. The likelihood and frequency of bad news forecasts dropped significantly for the Ninth Circuit firms.
Yeah.
But crucially, when they looked at positive news forecasts, there was no statistically significant change.
No change for good news forecasts.
Nope. Firms seemed to continue issuing good news forecasts at about the same rate as before, relative to controls. The adjustment was almost entirely on the negative side.
So if you're that manager in California post-1999, you're thinking, okay, the bar for suing us over bad news omission just got higher. We can pull back on proactively warning the market about potential negatives.
That's exactly the strategic thinking this result suggests. The bad news disclosures, likely serving as that preemptive legal shield, were the things managers felt comfortable cutting back on once the threat level decreased. Good news forecasts, perhaps serving other purposes like guiding expectations or attracting investors, seemed less affected by this specific change in litigation risk.
Okay, that's a powerful finding connecting back to the theory. What about the way they disclosed? Did firms change the quality of their forecasts or just the quantity? This is the extensive versus intensive margin question.
Right. The extensive margin is about whether to disclose and how often. The intensive margin is about the characteristics of the disclosure itself, given that you decide to disclose, like, how precise is the forecast range? How accurate does it turn out to be?
And the paper's Table 5 looked at this. Where was the main impact?
The impact was overwhelmingly on the extensive margin. The big statistically significant effects were on the likelihood of issuing any forecast and the frequency or total number of forecasts.
So they mainly chose to forecast less often or stopped altogether?
Correct. When they looked at the intensive margin measures like forecast precision, is it a point forecast or a range, how wide is the range, or forecast accuracy, how close was it to the actual earnings, the results were much weaker.
Weaker how?
There were some hints, maybe some coefficients pointing in the direction you might expect, like maybe slightly less precision when risk dropped, but they generally weren't statistically significant or robust across different model specifications.
So the main strategic lever managers pulled in response to lower risk was just talking less often, not necessarily changing how they talked when they did speak.
That seems to be the primary conclusion from that part of the analysis. The volume and frequency of the extensive margin appear to be the key tools for managing litigation risk through disclosure, more so than fine-tuning the quality attributes of the forecasts themselves.
Fascinating. And just to really seal the deal, they had the reverse experiment with the 2007 Supreme Court decision. What did that show?
Yes, that 2007 decision effectively undid some of the stringent pleading standards the Ninth Circuit had imposed, thereby increasing litigation risk again for those firms.
So the opposite shock.
Exactly. And Panel A of Table 8 in the paper shows basically the mirror image of the 1999 results. When risk went back up in 2007, firms in the Ninth Circuit responded with a statistically significant increase in both the likelihood and frequency of their earnings forecasts relative to controls.
Wow. Risk down, disclosure down. Risk up, disclosure up.
That's about as compelling as it gets in non-experimental research. Seeing the effect reverse like that provides really strong confirmation of the causal mechanism they identified. It really locks down the answer to the research question.
Okay, final structured question number 6. Synthesizing all this, what were the main conclusions the authors drew? And, critically, given everything we've discussed, the theory, the sophisticated design, the results, do those conclusions seem justified? Are they warranted?
Their core conclusion is straightforward. Lower litigation risk causes firms to reduce their voluntary disclosure, and this reduction is concentrated specifically in negative news forecasts. This confirms, they argue, that firms strategically use voluntary disclosure, particularly have bad news, as a tool to deter lawsuits.
In your assessment, are those conclusions warranted by the evidence they presented?
Oh, absolutely. I would say they are highly warranted. Within the context of archival accounting and finance research, where proving causality is notoriously difficult, this paper stands out for its methodological rigor.
What makes you say highly warranted? What specific aspects give you that confidence?
Well, first and foremost, it's the strength of the identification strategy. They didn't just rely on one event, using three distinct, plausibly exogenous legal shocks.
That pushed risk in different directions and covered different legal areas.
Right. That triangulation provides immense credibility. It makes it really hard to argue the finding is just some fluke tied to one specific time or one type of law. Any potential criticism related to one event is likely addressed by the findings from the others.
So the multifaceted approach is key. What else?
The way they tackle the indigeneity problems head-on. We talked about the three main issues: reverse causality, measurement error, and omitted variables.
And the design addressed all three.
I believe so. The exogenous nature of the legal shocks helps deal with reverse causality and measurement error inherent in using firm characteristics as proxies for risk. And the combination of propensity score, matching with the stringent difference in differences setup, especially using those firm and industry by year fix effects, provides a very strong defense against omitted variable bias.
They really threw the econometric toolkit at the problem.
They did. And then there's the alignment with theory. The fact that the empirical results line up so neatly with the predictions of the asymmetric loss function specifically, the finding that the effect is driven by negative news disclosure, provides a coherent story for why this causal relationship exists. It's not just a statistical correlation, there's a strong theoretical mechanism underpinning it.
So robust methodology, multiple validating events, and strong theoretical grounding.
Exactly. That combination makes their conclusions feel very solid. They successfully overcame the hurdles that limited prior research and established a benchmark understanding of how litigation risk causally shapes corporate disclosure strategy. It's a foundational piece of work in this area.
Okay, let's pull back for the big picture then. We've dissected the paper pretty thoroughly. What does this study tell us more broadly about, say, corporate governance or the role of the legal system in finance?
I think it makes a significant contribution to how we understand shareholder litigation. Often we think about lawsuits just as a backward-looking punishment for bad behavior or governance failures.
Right, a corrective mechanism after something goes wrong.
Yes. But this paper really highlights litigation risk as a powerful forward-looking influence on day-to-day corporate policy. It shows that the legal environment isn't just waiting in the background. It's actively shaping managers' strategic decisions, like how often they communicate with the market. It acts almost like a form of regulation, influencing behavior proactively.
And beyond disclosure, related research has shown these legal risk shifts can affect things like M&A activity or financing choices too, right?
Absolutely. It underscores litigation risk as a fundamental environmental factor influencing a wide range of corporate policies.
And for anyone listening who's doing research in accounting, finance, or even law and economics,
It's another powerful demonstration of the value of using these kinds of legal and regulatory changes as natural experiments. When you can't run a real randomized trial, finding these plausibly exogenous shocks is often the best way to get credible causal evidence on important business questions. This paper is a great example of that approach done well.
okay, so it's methodologically instructive too. Now, looking forward, what's a lingering question or a future research direction this paper opens up? You mentioned something about the quality versus quantity of disclosure earlier.
Yes, I think that's a really interesting loose end and maybe the final provocative thought to leave people with. The paper found very strong, robust effects of litigation risk on the quantity of disclosure, the extensive margin, the volume, the frequency.
Right. They talked less when risk went down.
But the effects on the quality of disclosure, the intensive margin, things like forecast precision or accuracy, were much weaker, often not statistically significant.
What does that imply?
Well, it raises a question. If managers are primarily using disclosure volume and frequency as their main defense against litigation, maybe just to shorten that class period and show they're communicating regularly, does that mean the actual informational quality of the message takes a back seat when legal risk changes?
Are they just focused on checking the box, making sure they issue something frequently, rather than ensuring that something is as informative as possible?
That's the question. Is the primary defense mechanism about timeliness and volume, and is the quality of the forecast perhaps secondary or even tertiary when managers are strategically responding to shifts in the legal environment.
So understanding the trade-offs managers make between disclosure quantity for legal protection and disclosure quality for investor information in different legal regimes, that's still an open area.
I think so. How does the constant pressure of liability avoidance potentially shape the long-term quality and genuine usefulness of corporate disclosure? That seems like a really important frontier for future research, directly inspired by the nuances in this paper's findings.
A fascinating question indeed. Well, that brings us to the end of this deep dive into a really pivotal study on litigation risk and disclosure. A huge thank you for walking us through that.
My pleasure.
And for everyone listening, we hope this breakdown gives you that shortcut to being truly well-informed on this complex topic. Thanks for joining us on the deep dive, and farewell.
Thanks for tuning into the Lion's Share podcast. If you enjoyed today's discussion, share it with a friend and join us next time for more ideas worth talking about. We'll see you next time.